Today we're going to be talking about the road to independence. And this is quite important because it's a year when we're focusing on the 250th anniversary of independence, USA at 250, starting July 4th of this year. So it's wonderful that Richard McMaster who is a specialist, particularly in pre-revolutionary war issues, as a historian, is able to speak with us about what really is important to him. He's a retired professor of history, and he did some work at University of Florida, but most of it was elsewhere, East Carolina University, I believe. I tried to look up his CV on the internet and found that the latest that I could find was something from 1975. So he's done a lot since then, and he's really well known in the Gainesville area because of his work in trying to preserve the rights of immigrants, particularly through the religious community and the Mennonite church that he and his wife Eve were so devoted to for so long. So Richard, why don't you go ahead?
Thank you. We are returning to the classroom. We're returning, there we go, way to do it. We're returning to the classroom experience of 50 years ago because I tried desperately to put a PowerPoint together, and I'm afraid it got the better of the deal. So I couldn't get it to Pam. So we're back to when the cutting edge tool in the classroom was a blackboard and a piece of chalk. So we'll try on that. Well, looking back again into the past that many of you probably will remember, in 1957, Queen Elizabeth came to Virginia to dedicate the 350th anniversary visitors center at Jamestown. And I saw that, I wasn't there in 1957, but I saw that just a couple of years later. And what it did was to show you that most of the political institutions, and with them the liberties of America, were deeply rooted in the transition from England. And when I came back again, maybe in the early 70s, that was all pretty much gone in the interest of having a more diversified understanding of our history and our shared past. So I wanted to use that as a stepping stone to looking at the rights of Englishmen. Even well, let me just add one thing there, that in the 18th century, we probably had, with a much, much smaller population, a more diverse population than at any time since. That we, as you know, we had a transplanted southeastern England in Massachusetts and Connecticut, but as we move further down the coast, we had huge areas in New York and New Jersey where people spoke Dutch. Even in 1775, Martin Van Buren, born in 1782, didn't speak English or learn English until he was 12 years old. He didn't need it, it was a Dutch community. And as we move into parts of New Jersey, parts of New York, the Mohawk Valley, especially Pennsylvania and all the way down to Georgia, people spoke German. You had large areas where this is solidly German, and alongside them, Scotch Irish and Scotch, and all the cities, you had significant uh, communities of Sephardic and a few Ashkenazic Jews. You had Catholics in Pennsylvania, both rural and in Philadelphia and in Maryland. You had all sorts of people, many more than we could. But these people talked about, we have the rights of Englishmen. And it had nothing to do with, were you English? Did your grandmother come from Kent or something? It had to do with, this is what everybody has. So in 1606, before a single English colonist arrived at Jamestown, they came a year later, Sir Edward Cook, who is famed as being one of the really progenitors of not just the English common law, codifying the common law, but relying on the courts as a totally independent part of a trilogy of monarch, parliament, and the law. So he was asked to draw up the laws of Virginia for the Virginia Company who were going to settle at Jamestown. And one of the points he made there was that every colonist would be guaranteed all the rights, privileges, and immunities of anyone born in England. So the rights of Englishmen were written in there before there was an English colonist in North America. And 2 years later, because the King, James I of England, was also James VI of Scotland, that was extended. It wasn't just the rights of Englishmen belonged to Englishmen, they also belonged to anyone born in Scotland. So that was an extension that was made. Now, what were these rights? When they were talking about the rights of Englishmen, what were they really talking about? Well, in many cases, people would go back to Magna Carta. As you will remember, Magna Carta was a grant of rights and privileges extorted from King John in 1215 by the Norman barons in England. And I was under the impression, as I'm not a medievalist, I was under the impression that it was a one-off. You know, there at Runnymede, alongside the Thames, these nobility ganged up on the king, and he said, okay, I'll sign it, that's fine. And that was the end of it. But I was reading an article just the other day about the discovery that the copy of Magna Carta that is in the Houghton Library at Harvard was, in fact, not a 16th or 17th century copy as it was cataloged, but was, in fact, one of a multitude of original Magna Cartas that not only were kept in various places all over England, but they were copied for about 150 years after King John's original grant, and they added things. Sometimes it was specific. The copy in Lincoln Cathedral would add something that gave the freeholders of Lincoln these rights. And other times it was just a general thing. But this continued down to about 1375. And this Harvard copy was one of these. Well, what was in it? What was John and his successors forced to concede? Number one was that the monarch and his government were always to be subject to the law. And a very significant point on which many, many years later, Cook and Blackstone would build, that, you know, the king, the president, is not above the law. He is subject to the law, just like a beggar man in the street would be subject to the law. And they insisted on the right of a trial by jury of one's peers, and also that there would be no extraordinary taxes, and that Parliament, this is way back in 1215, Parliament would always have a role in appropriating money. Now, this was built on some monarchs over the next several hundred years, backtracked. Some parliaments got a little bit ahead, and it's in the, I'm skipping now to the period when they're beginning to colonize North America in the 17th century. In the 17th century, we move into codifying and making permanent all of these rights, not just in some general way, but this is it. There is an agreement in 1623. Remember, the Mayflower was 1620, so it's very much the same time, called the Petition of Right, which doesn't tell you anything by the name. And what it was to say that the king had no power whatsoever to lay taxes or tariffs without the consent of Parliament. So we're beginning to get Parliament through the 17th century saying that, you know, it isn't just the king, like in France and certain other places, or the czar. The king here is a subject of the law and has to work with Parliament if he wants to appropriate money for one source or another. It's a slightly partisan comment as an aside. It's interesting that even in the 17th century, it was argued that British monarchs did not have the power to do the things that American presidents can do. So, like, for example, laying tariffs and taxes without looking at Parliament. Parliament had to take part in it. In 1679, well, let me just go back 1 minute there. It was this issue of the king wanting to raise money without the consent of Parliament that led to the ultimately the English Civil War. The case in 1640 where King Charles I, James's son, had attempted to raise money, the ship money case, that he, without Parliament, that they challenged the first time in 1640, and that ended with Charles I being tried and executed in 1649, and Parliament now was supreme. But then, you remember, Oliver Cromwell came in, and they learned after a very few years that you didn't have to be born in the royal family to aim at being a tyrant or an autocrat. So his last years, he was very, very, I am the state, just like Louis XIV in France. And then his much less competent son, Richard, by 1660, they decided they'd had enough Cromwells, and they threw him out and brought back Charles's son, Charles II. And it was in the reign of Charles II that another important document was adopted. In 1679, Parliament passed the Habeas Corpus Act, which guaranteed that you could not be imprisoned, you could not be fined unless you had been convicted by a jury of your peers in your own neighborhood, not a case moved from somewhere in Cornwall to Newcastle or even worse to Edinburgh. And similarly, that you had to know, they had to tell you if you were arrested, what are the charges against you? You can't just be swept off the street by masked men at night and taken away to a prison. They have to tell you what you have done, and they have to bring you before a magistrate, and then you are to have a jury trial. So that very important right was codified in 1679. Now, I want to switch back across the Atlantic to this side of the Atlantic. By the time that Charles died and his brother James II took office, the American colonies had developed considerably from the tiny kind of just a handful of people in Plymouth and a handful of people in Jamestown. These were very much the colonies that we know in the 18th century. And at that point, if we look at New England, in 1630, the Massachusetts Bay Company, which had a right to settle in the North Shore of Massachusetts. The Plymouth colony was the South Shore in Massachusetts, Cape Cod and all that. The 1630, the Massachusetts Bay Company, led by John Winthrop, carried with them the charter of the company. Now, the charter of the company, I am not anybody experienced in business, but I think this is almost exactly what any incorporated company would be today, that they were to have an annual shareholders meeting, and that the shareholders would elect a board, and that the board would elect people to administer the company. And that's what the Massachusetts Bay Company Charter basically said. And when they brought it to New England, they said, oh, this is the government of the Massachusetts Bay Colony. So everybody votes, everybody elects people, and initially it was actually like a big annual shareholders meeting, but there were just too many people. So it just became a general election to what they called the Great and General Court. The General Court elected the upper house and the governor and the other administrators. So they were, for all practical purposes, an independent commonwealth. They didn't have to worry about anything that Parliament did and so on, at least in their own mind. And this model then is followed in Connecticut and Rhode Island, Providence Plantation, in Plymouth, and in New Hampshire. The rest of the colonies were either royal colonies. Virginia, for example, the company kind of went bankrupt in 1625, and the king took it over. So the king appointed, or his people, appointed the governor and the council and the upper house, but we still had a freely elected House of Burgesses. And that model is followed pretty much in all of the colonies, except those that were proprietary colonies, where the king, in this case Charles II, who was not, he was exiled when he came back to England. He was an exile. He didn't have pots of money, so he decided the way to raise money and to reward good friends and so on was to create proprietary colonies, as, for example, Pennsylvania. Pennsylvania was not a royal colony. It belonged to the Penn family, and they could do all the things that the royal government would do. Well, in 1686, James II decided that this isn't really the way to go. So he created the Dominion of New England, canceling all of the New England charters, and a year later, throwing in New York and New Jersey. So they all became one colony with one royal governor, Sir Edmund Andros, and he was responsible for all the British colonies north of Pennsylvania. Obviously, this was not very popular with the people who lived there, but there wasn't much they could do about it. Now, we're about to get into that wonderful document that I asked Pam to copy for you. In 1688, James II, who was increasingly unpopular in England, partly because he was a Roman Catholic, and the nation was at least officially Protestant, and that enters into it, of course. But he made the mistake of, by his Portuguese wife, a princess, having a child, because in 1688 they assumed, well, we'll put up with James for a while, but he's going to die. He has no immediate heir, certainly no Catholic heir. And then all of a sudden he did. So they decided that it was time for James to go. And James, threatened by his daughter and son-in-law, William and Mary, William the Stadtholder of Holland, who was Prince of Orange, and his wife Mary uh, were invited to take the throne. And James, rather than fight it out in England, went over to Ireland and had raised an army there with a great deal of French support. Most of his army were actually French. And William, when he went over to Ireland to fight James, brought an army that was very largely Dutch and Danish, and not really a certain number of English units in it too. And in 1690, as they celebrate in Northern Ireland, on the 12th of July, King Billy met them at the Boyne and thrashed them, and James decided essentially the game is up, and that was it. Now, a bit earlier, in April 1789, now I need a third hand here, but I don't, fortunately. I want to be able to say, let's look at this wonderful document.
Okay, go ahead.
Let's look at this wonderful document. I think it's, I'm going to be all right. I'm not as inept as I look or appear. So, I can handle this. Look at this first page. What do they begin by saying? The English Bill of Rights. That whereas the late King James II, by the assistance of counselors, judges, and ministers, and so on, did terrible things. What does this remind you of? What document in American history is this very like? What? The Declaration of Independence. I think it's almost certain that if he didn't have it in the back of his head, Thomas Jefferson had a copy of this sitting in front of him when he was working on the Declaration of Independence. It follows the same kind of pattern, that the king has taken all of these assumed rights, the power of dispensing with and suspending laws, and the execution of laws without consent of Parliament. And a couple that deal with Bishop Trelawney's case, and then levying money for the use of the crown by pretense of prerogative. For other times and in other manner than was granted by Parliament. Parliament can only deal with money. By raising a standing army in times of peace without the consent of Parliament. By causing several subjects, being good Protestants, to be disarmed at the same time that now we're getting into the American Bill of Rights, that they shall not be deprived of the right to keep and bear arms. And let's go a couple more here. By violating the freedom of election of members to serve in Parliament. Now, the election of people to Parliament wasn't exactly democratic. In many cases, a large landowner would have the right to nominate someone, and perhaps a dozen of his freeholders, people who actually had some land themselves, would vote for him. So you could hardly say that, you know, the mass of people chose Squire Jones to go to Parliament, but nevertheless, it was a free election. And interfering with the courts, and various other things here. Oh, and now we're getting again into the Bill of Rights, our Bill of Rights, that excessive fines cannot be imposed, illegal and cruel punishments, and so on. So it's a very powerful document in that way. And now we get into what they want to say is the rights of what are the rights of Englishmen, and let me continue looking at this as best I can. That the pretended power of suspending the laws or the execution of laws by royal authority without consent of Parliament is illegal. That the pretended power of dispensing with laws or the execution of laws by royal authority is illegal. And dealing with the creation of these special courts is illegal. Levying money for and to the use of the crown by pretense of prerogative without grant of Parliament is illegal. The right of the subjects to petition the king and all commitments and prosecutions for such is illegal. The raising or keeping of a standing army in time of peace without Parliament is illegal, and so on. Elections should be free. The freedom of speech and debates or proceedings in Parliament. And this continues to the present day, that if I say you are a corrupt and evil person inside the House of Commons, no problem. And if I walk across the street and say you are a corrupt and evil person, you can charge me with libel and prosecute me and probably be successful. But and jurors and jury trials and so on. So it's a fascinating document that sets really the parameters of what we mean in the 18th century by the rights of Englishmen. And as we move through the 18th century, it's amazing how the power of Parliament grows. And with it, this idea of a balance of powers, that the monarch is, yes, very, very important. Parliament is very important, but the common law is also independently very, very important. You cannot act without the whole precedent of years and years of court decisions. So, for example, the last time that a British monarch set aside a law was in 1708. So George III had no power to do that. Nobody would have allowed him that. And similarly, the wings of the monarch kept getting clipped regularly. So by the time we move into the period we're going to be dealing with mainly from now on, from about 1760 to 1776, these were just taken for granted. Montesquieu wrote his book about the wonderful balance of power in the English Constitution, and we've all valued that so much over the years. Well, naturally enough, people in the colonies were looking at this and saying, do these rights and privileges extend to us. And as far as they were individual, personal things, nobody denied that. No, of course not. You can't just be taken off the street and thrown in a prison somewhere, no charge. You can't be arrested for publishing a newspaper or something. So, but the political structure, the first sign, and this was actually under William and Mary, was the revocation of the old, it had already been revoked, but that was James. So they revoked the Massachusetts Charter and appointed a royal governor, and the governor and the council and the judges would all be appointed from London. And they were very concerned about enforcing the customs so that people didn't get away with smuggling left and right, which most people did. Also, they did in England. And so that was sort of the beginning. Well, by 1760, in every colony, you had a governor, a royal governor, or in the case of Pennsylvania and Maryland, a governor appointed by the proprietor, but appointed from England. You had the upper house of the legislature was appointed from England. The judges were appointed from England. The Attorney General was appointed from England. The Board of Trade and Plantations and the Privy Council had to approve every law adopted by a colonial legislature. The governor had the power to veto a law, and the Board of Trade and the Privy Council could simply outlaw anything that the legislature had passed. So there is a really considerable feeling in the colonies that all of these wonderful gains in the political structure that became the rights of Englishmen, why don't they apply to us? Why should a appropriation of money be done in England? Why should there be taxation by people who don't actually represent us when we have a perfectly good legislature, and on the model of Parliament, we should be able to lay our own taxes, lay our own tariffs, etc. So that was this whole sense of underlying the revolutionary, pre-revolutionary discontent is, do the rights of Englishmen really extend, as Sir Edward Coke had said in 1606, to every colonist? So that's the question. I have probably talked too long, I don't know, but I like the sound of my voice. So I turn it over to you. Where's Pam?
Hold on, I'll come up there.
Where's Pam?
Okay, let's go with you.
Thank you. My name is Ann Webster, and I was just wondering, as the people in the colonies were starting to ask why aren't the rights of Englishmen that exist in England applied more to us, to what extent was there, at that time, the development of local governments in the colonies? I'm sure it differed from one to another. And I'm wondering, and I'm thinking of the town hall system in, at least in Massachusetts. I don't know when that began, but I'm guessing that if it was in existence in the, say, 1600s or late 1600s into early 1700s, that perhaps people's satisfaction with that very local system would have contributed to these feelings of, well, difference between here and across the pond. Is that true?
Yeah, I think so. The they voted by towns from as soon as they realized that it'd be very difficult to get everybody who lives in Massachusetts Bay into one place for a meeting. That's, you know, you can't do that. Too many people, they're not going to travel all over. They were voting by towns. So the town meeting, which is very strong, was the place where they would vote for the legislature and so on. And the towns necessarily had some had interests that imposed on the interests of others and so on. But so when I was a graduate student, there had been a recent book, I forget the name of the author, but it was Middle Class Democracy in Massachusetts. And everybody wanted to do a doctoral dissertation on middle class democracy in Connecticut, in South Carolina, whatever, and see if that was true. But apparently it was a very democratic situation that by the middle of the 18th century. I don't know if I said the right thing there because I'm slightly deaf.
Larry Lowenthal. Can you identify by the names of the people or the groups or any books that inspired the progressives in England in the 1680s? Who was stirring up the pot?
What?
Who was stirring the pot?
Who? Oh. Well, it's a very turbulent time. There are parties. We had Monmouth's rebellion. There was an armed rebellion in the West Country, and against James. James was modeling himself on the French king, and he was also not a Protestant. So there were all sorts of factions that opposed him and his autocratic rule. But obviously there are other people who thought he's wonderful. You know, this is great. So.
Other
Yes.
questions?
Yes.
Okay.
I may actually be able to hear you.
Hi, I'm Eve Burko. Can you clarify who were the English men who had these rights in the 17th century? Were they British-born noblemen, women, foreigners? Who had the rights?
Who has the right to do what?
The rights that were written.
Oh. Well, theoretically, anybody born in England, or Scotland. They didn't extend to Ireland, but they did to England and Scotland, Wales, and it's one of those things that the political structure is, you know, every freeholder can vote. Everybody who has a 40-shilling piece of property, real estate, can vote. You are a yeoman. And they did. But these people are not the bulk of the population. A great many people had no role in this at all. And in many cases, because of the class structure, you had Well, it's probably true anywhere and everywhere. You had people who, because they were great landowners or they were wealthy merchants, had more influence with things like the Board of Trade and so on than other people who were, legitimate members of the community. And then lots and lots of people didn't really have a voice in anything, but that was the way it was, and it will run all through the first half. Well, even, gosh, it's Gladstone toward the end of the 19th century before you're able to say, well, you live here, you are a citizen, you have a right to be heard with your vote and so on, or to be elected. So, and in the colonies, it's very much the same way. Uh, there was a kind of cursus honorum, a stepping stone of offices, that if you were a Virginia planter of a certain size, you would expect that you would serve on the parish vestry, you would be an overseer of the poor, you would be elected to the lower house, you might well be elected by England to the council, and so on. So, but others need not apply. So it's interesting. Interesting.
Any other questions? Okay.
Follow-up to this question, um, how was this information passed on to the folks in the colonies, i.e., how would you know that you were supposed to do this sort of stuff? I mean, was it sort of word of mouth? I mean, how would you know that you were supposed to do this sort of thing? I guess it was.
Well, it depends on just when it is. Uh, in the 17th century, obviously, communication would be quite limited.
Mhm.
But by the end of the 17th century and in the 18th century, you have newspapers.
Yes.
And so when, for example, in 1689, it was clear that William and Mary had replaced James, a coalition of merchants and members of the lower house in Boston arrested Andros and ended the dominion of New England. But by 1760, there were newspapers that circulated, and it was largely a case of newspapers that had tremendous number of readers. And so it wasn't just like I bought the New York Times and then I tossed it. It was like I shared the New York Times with everybody in this room. And eventually they got to read today's paper, and maybe it was a week old, but that was all right. So that was a very important part of that. And by the early 18th century, you had a postal service in the colonies, and so that information flowed rather quickly. I just to give you an example with the newspapers, Ben Franklin published the Pennsylvania Gazette in Philadelphia. It was not unknown, and I was struck by it one time. I taught at James Madison, Harrisonburg, Virginia, in the Shenandoah Valley. It was not unknown to have an advertisement for the sale of a horse in Stanton, Virginia, printed in Philadelphia. Well, you wouldn't do that today. You wouldn't, if you were having you were selling your house in Gainesville, you wouldn't advertise in the Philadelphia Inquirer, you know, but they did because these papers are, so the news got around pretty quickly. So, well, I thank you for your patience.
Thank you, everybody, for coming. Thank you, Richard.